So good morning, everyone, and it is my pleasure and it is an honor for me to have here Professor Martin Laughlin from the London School of Economics and Political Science. He is Professor of Public Law in that institution. He was a Professor of Public Law previously in Glasgow and Manchester, and he is author of important articles and books, in particular of a book called The Foundations of Public Law, published in 2010, which is an important book on developing argument of constitutional theory and constitutional history, I would say also. But this is not a book I would suggest to first-year student. It is a quite complex work, whereas he has more recently written a book, which is this one, The British Constitution, a very short introduction, which is much more accessible, and it is a book which is more pertinent to the guest lecture he is going to give us today. I would like to say a few words on the purpose of this lecture. As you have seen in the syllabus, this week will be mainly devoted to exploring the definition and the types of constitutions. Although last week, in mapping the field of comparative constitutional law, I already provided a provisional working definition of constitution. If you remember, I said that a constitution is a set of norms regulating public institutions, attributing powers, regulating also the relationship between public institutions and individuals. I added to this first working definition another, perhaps more profound definition, presenting the Constitution as a fundamental law, defining the identity, the structure of a political and legal order, reflecting the identity and shaping the identity of a legal and political order. Now, I'm quite sure, and this was something I pointed out already last week, that in facing with such a definition of constitution, we, and when I say we, I intend myself and probably most of you, and not Professor Laughlin, as continental lawyers or aspiring lawyers, students of legal studies, we tend to conflate the notion of constitution with the notion of modern constitution we'll learn today. In our assumption, in our hidden approach to what a constitution is, we tend to think, for instance, that a constitution is a written document, and secondly, it is a document which is the result of probably the highest manifestation of political will, the constituent power. But this is only a part of the story, a part of the definition. If we conflate the notion of constitution with the notion of modern constitution, we are in a way misled. It is an association which is flawed, as some of the generalizations that populate our imagination. Reality is more complex because in a number of jurisdictions, and in particular in Great Britain, in the United Kingdom, the same functions of a modern constitution are performed by norms which have a different nature and origin. The British Constitution, as I said, can be regarded as an example of a traditional constitution defying the generalization I was mentioning before. Professor Laughlin today will help us, first of all, understanding these two alternative conceptions of what a constitution is, and secondly, I had a look to the slides, he will also discuss whether the traditional constitution is nowadays a tenable concept, is able to cope with contemporary legal and political developments. Just for your information, the lecture is recorded and therefore will be accessible also afterwards, and also the slides that Professor Laughlin will use will be made available. Martin, the floor is yours.
Thank you. I would prefer to stand, but I don't want to carry this around, so I'm going to sit in order to be captured by the microphone. First, I should thank Marco for inviting me here. I understand you have a very exciting new degree program, and I'm envious. It's a challenging program, but it looks as though it's a very interesting and exciting one. So I wish you well with it, and thank you very much for this invitation today. What I wish to do, if I can bring up my slides. What I wish to do, I'm going to give you an overview here of what I'm proposing to do in talking to you today, is first to talk about constitution and constitutionalism, two different concepts, then to draw a distinction between the traditional and the modern idea of a constitution. The modern idea of a constitution is, of course, the one that dominates the world. Actually, the British Constitution is the only real remaining constitution of a traditional character. So the rest of the time I will try to explain how the British think about the Constitution and the problems that we have today in continuing to think of our Constitution in a traditional way, given the pressures that we face. So what remains of the traditional constitution? And I've no doubt, you're quite early in your career, I've no doubt I will say things that will be puzzling. If at any stage you don't understand, please just ask a question, raise your hand and ask a question. If you don't understand, I can guarantee the majority of people in the room will not understand what I'm saying, and therefore you will be doing the class of service. If you say, excuse me, I don't understand that point, please don't hesitate to ask questions at any stage. I hope I will leave time at the end to allow general questions, obviously, but if at any point during the course of what I'm saying you don't understand anything, please do ask. Okay. Let me start with a long quotation from Dieter Grimm. Dieter Grimm is a professor of public law at Humboldt University in Berlin. He is a former justice of the Federal Constitutional Court, the Bundesverfassungsgericht in Germany, and in just last year he produced an English translation of many of his essays on constitutionalism, and here he writes a general statement about constitutions. Every political unit is constituted, but not every unit has a constitution. The term constitution, he's saying, covers both elements, both the constitution of a unit and a made constitution. In the first sense of the word, he's saying it refers to the nature of a country with reference to its political conditions. In the second, it is a law. In the first sense, he's saying the Constitution is simply a descriptive or an empirical phenomenon. This is how a country organizes itself politically. In the second sense of a constitution, it's a normative phenomenon. It's establishing a law or a set of laws, a set of norms that hold out certain values and procedures and principles by which political power within a particular unit, a state, is exercised. What Grimm here does is draw a distinction, effectively the distinction I want to make between traditional and modern constitutions. Traditional constitution, Grimm would say, is a descriptive idea of a constitution. It's a reference to a country by reference to its political conditions. And as the politics of a country changes, so its political conditions change, so its constitution changes. In the second sense, a constitution established standards that ought to remain relatively fixed, and they act as a measure against which to assess the politics that's being undertaken in a country at any particular moment. And if we extrapolate from what Grimm's saying here, we can draw a distinction between constitution and constitutionalism. If we look at constitutions purely in the descriptive sense, we are just describing the political conditions that work in any particular country across the world. If we talk about constitutionalism, we are talking about a set of normative ideals that ought to regulate the exercise of political power of any country that aspires to be a constitutional democracy, let's say. And one of the key doctrines of constitutionalism is that power, political power, must be dispersed and subject to controls. So a key doctrine of constitutionalism is the doctrine of the separation of powers. That in every political system, there are three basic functions through which political power is exercised. One is the rule-making function. Another is governing within the framework of those rules. And a third is interpreting the rules whenever there's a conflict about the meaning of the rule. The first, rule-making, is the legislative function, the making of laws. The second is the executive function, governing the government of the country within the framework of those laws that have been enacted by the legislature. And the third is the adjudicative function, the role of the court in resolving disputes about the meaning of those basic rules. And in the court's constitutional role, its function essentially is to ensure that the executive keep within the framework of the rules that have been enacted by the legislature. And when that idea of a differentiation or separation of powers exists, then you have the rules being made by one institution, government being carried out by a different institution, and adjudication exercised by a third function. And you have set up a very elaborate rule system whereby each checks and balances the powers of the other. And you then have the rule of rules. And the rule of rules is sometimes called the rule of law, and the rule of law is the correlative idea of constitutionalism. But that's getting ahead of myself. Let me come back now to the distinction between traditional and modern constitution. So, let me start with the traditional idea of a constitution and start with two quotations from very distinguished theorists of very different type. First, Edmund Burke. I was going to say a British political theorist, but actually he's Irish. But Irish by birth, British by career. His most famous essay is these reflections on the revolution in France. And he has many things to say of a critical nature about the nature of the French Revolution. But all I wanted to draw out was this small statement from Burke, where he says, a constitution is a partnership not only of those who are living, but also between those who are living, those who are dead, and those who are to be born. So, whereas constitutionalism, the idea I've just tried to explain, whereby you separate the power horizontally, so to speak, is a modern idea of constitution. Burke is saying a constitution differentiates the exercise of power temporally. There's a partnership, a balance between the rules of the past, the rules of today, and the rules of tomorrow. So there's a sense that a constitution is an evolving organism, and the constraints on the exercise of political power today are primarily a product of a history, of a culture. And those who exercise power today ought to be conscious of their responsibilities for future generations. So that's a strong sense of tradition. And Burke is saying that's the essence of what a constitution is about, a culture, a set of ways of acting that have a continuity through time. So Burke here captures one idea of a traditional constitution. Now let's come to a very different thinker, Georg Wilhelm Friedrich Hegel, classic German idealist in his philosophy of mind, sometimes called philosophy of spirit. We don't like the idea of spirit in English temperament, so we translate it as mind. In his philosophy of spirit, we have Hegel here saying, what is called making a constitution is a thing that has never happened in history. You can't make a constitution, Hegel is saying. You can't make a constitution because a constitution is something that only develops from, very Germanic idea here too, a national spirit. You can no more make a constitution, says Hegel, than you can make a language. A language is something that evolves through time, and its usage, the usage that we make of a language, changes according to cultural circumstances. And a language is an evolving, living thing that the responsibility of which is dependent on its usage through time. a constitution, Hegel is saying, is not a mechanism. It's not an artifact. It's not something you can just construct. We have tried, there have been rationalist exercises in the past to construct, to get rid of all of the complexity of the multiplicity of languages in the world by developing a rational language called Esperanto, and it didn't catch on because it's misunderstanding what a language is. It has to live in people and live in a community to flourish. And so Hegel is saying, so too is a constitution. A constitution is a culture, a way of being, a way in which a people view itself as a collective, as a political collective. And it's a set of habits and practices and customs. So, that's a background on the traditional idea of a constitution. Let me come to the modern idea. And what we might say in retrospect is that Hegel, who was writing in 1830, writing in 1830, a very old text of, if it were an 1830 text, we might say that in retrospect, Hegel was wrong. Because in the late 18th century, the colonists that were part of the British imperial venture in North America, for crazy reasons, I would say, decided that they would be better off going alone and not being subjects to the British crown. They exited, but they had to fight a war of independence to do so. I don't know how, but they won the war of independence. And the colonies, the 13 original colonies, initially formed a confederation, which was a loose affiliation. And they felt that this was not conducive to national development, so they formed a Continental Congress, and they deliberated and they debated, and they came forward with an idea of a federal constitution. And having drafted a federal constitution, they had to sell it to the American people. And one of the great classic texts of a modern constitutional thought is the work of three of the players in this Congress: James Madison, Alexander Hamilton, and John Jay. And they variously, under the pseudonym of Publius, they wrote a series of newspaper articles, really, trying to convince the electorate why they should adopt this federal constitution. And they are gathered together as the Federalist Papers. And in the first of the Federalist Papers, we have Alexander Hamilton writing, "It has been reserved to the people of this country to decide an important question. And the question is whether societies of men," he means societies of people, societies of men are really capable of establishing good government through reflection, through choice, through consent, or whether they must rely for their political constitutions on accident and force. Now, the first point to note out of that statement is that where Burke and Hegel, in their different ways, are talking about a partnership between past, present, and future, or the emergence of a culture and a spirit and a way of being, Hamilton is saying that's force, conquest, accidental circumstances. For Hamilton, those inherited traditional constitutions are the ruling of the living by the dead, and they are the power holders of the past who are dominating and dictating the political conditions of the present. And he's saying what we as a people should be able to do is to reflect, deliberate, agree a constitution, a framework of political rule under which we might all be governed. And what happens in the late 18th century, in 1787, is the Americans make the world's first modern written constitution. And if we're interested in trying to distill the essential characteristics of a modern written constitution, then we can get some guidance from another tract written in this period, Thomas Paine's Rights of Man. Paine says this in his book, Rights of Man. First, a constitution is a thing. It is made. If it doesn't exist, if it has no tangible present, there is no constitution. And as we know, if I ask most people from around the world, do you have a constitution? And they say yes. And they say, how do you know you have a constitution? They just give me a document. They hold up a document and say, there it is. This is the constitution of my country. It's a text. It was written at a particular moment in time. It has a material existence. It's not some vague sense of a cultural way of being of a people. Secondly, Paine says it is antecedent to a government. That is, the Constitution is what constitutes the government. It's what makes the government. The government is a creature of the Constitution. Government is not some natural entity that exists, has always existed. We'll come back and see the significance of that in a moment. It's not something that always exists. The authority of government is created through the Constitution. And then Paine says, thirdly, a constitution provides a comprehensive framework which contains all of the principal aspects of the exercise of governmental power. So the Constitution should lay out the powers and the limits to the powers of the legislature, executive, and judiciary, the relations between them, the modes of their appointment, the sources of their accountability. It should be a comprehensive framework through which all legitimate political power is exercised. And then finally, and this is the great innovation, the others are clarifications and innovation, but the great innovation was finally the Constitution is fundamental law. Well, Paine says, it is to a government what the laws made afterwards by that government are to a court of judicature. It's a convoluted way of saying that just as a legislature makes the rules and the judiciary is bound to follow and interpret and maintain fidelity to the rules made by the legislature, so too must the government, he means government in the broad sense of legislative, executive, and judiciary, so too must those institutions of government maintain fidelity to this higher law, the Constitution. So the Constitution becomes a new type of law. Laws are not just measures made by a legislature. There's a special type of constitutional law, which is the law that authorizes the legislature to make laws. And if the legislature tries to make a law that exceeds its authority, of boundaries of its authority in the Constitution, then the function of the judiciary is to strike down that law as being unconstitutional, contrary to the fundamental law that is laid down in the Constitution. So modern constitutions do their work because they take effect as fundamental law, as a higher category of law than the ordinary laws that are made by the legislature. Okay. Any questions so far? Can't believe it's that clear. Are you sleeping? Yeah.
Well, more than a question, it's just that I got it right. Dream says that there could be a certain type of conflict because according to the constitutionalism, the people makes the rules for the government. The government makes the rules.
Mm-hmm.
If people break the rules, the government must enforce. If government breaks the rules, let's say the constitutional rules, it's also the government that should enforce the government. I got it right. So it
Okay.
could be somehow a kind of conflict, in my opinion, because in this way, says that constitutional law in some situations and some countries is not always respected.
This is a very sophisticated question. I shouldn't have asked for questions because I get a very sophisticated question, which I'll try and answer. I'll try and answer quite briefly. Let me turn to another theorist I haven't mentioned, English political theorist John Locke, who who is a great inspiration for the framers of the American Constitution. And what Locke says is that if a legislature acts contrary to the terms of the delegated power that's been conferred on them by the people, the compact, the basic social contract between the people and their institutions of government has been broken. And Locke says, and then the people have the right of rebellion. Now, he's not just saying the people can rebel, because the crowd, the multitude, can always rebel. The crowd can, whatever constitutional or legal forms might say, the political reality is such that if there is force to overthrow a government, that will happen. But what Locke is saying is the people have the right to rebel. He's using an idea of natural law here. There's a natural right to live under government to which you have consented to. And if the government breaks the terms of that compact, that consensual contract, then the people, then they lose their authority and the people have the right to rebel. And that's what lay behind the American colonists' challenge to the British Crown. They said, you have broken the compact because you're trying to tax us without our having representation in the British Parliament. And that's contrary to the natural common law rights of the English people. And that's not part of the compact, and therefore we have the right of rebellion. Now, what constitutionalists would say is that in the modern era, with the establishment of these comprehensive constitutions, the people no longer have that right to rebel. That right to rebel, I'm elaborating a bit, that right to rebel is converted into a right to go to the Constitutional Court to say the government has broken the Constitution. And so the right is converted into a right within the constitutional order.
Yeah.
No?
I got the part also, but okay. Yeah, I read this part of the judiciary review, but in my opinion, isn't it still the government enforcing the government, even through a constitutional court or something like this? I mean, more directly, in your opinion, it will be more fair to keep the right to rebellion or to insurrection, I don't know, more than, again, trusting a government that already has somehow violated an agreement?
Well, John Locke's views would be directly opposed, I'm sorry, I'm going to give you yet another name, by Thomas Hobbes, another English political theorist of the 17th century. And Hobbes says, you can't give the people that type of right. If you give the people that type of right, then you are making government prey, subservient, I mean, prey with an E, not with an A. You're making the government subservient to every crazy individual with a rifle in their hands. And that, Hobbes would say, were he still alive, he has been dead for a long, long time, is the problem in the United States, for example, where crazy Confederalists think the government, the federal government, has broken the Constitution because it's taking too many powers that really should be left to the states. And therefore they'll say they've broken the compact and therefore we have the right to assassinate the president. That's what it leads to, Hobbes would say. It's a destruction of all idea of authority, and that's why in terms of constitutional ordering, the rights have to be within the frame of constitutional discourse. Now, you might say beyond constitutional discourse there is pure force. And that pure force does its work at various places in the world at various moments in time. But we can't conceptualize that through constitutional right. You can simply say there is a material force That is part of the material reality of contemporary politics, but it is not grounded in a notion of constitutional right. So it's right rather than power. Your own native-born radical political theorist Antonio Negri would have this view that the multitude have this right to overthrow the regime. But that's a very radical idea. Nothing wrong with radical ideas, but it's anti-constitutional. It's positing a political power to challenge constituted power on the grounds that constituted power is domination, and it cannot be seen as anything other than domination, and the idea that it's built on consent is fake. Okay.
I can add just, I think the question that Randall posed is an important one that we are going to address at the very end of this course, and we'll ask whether a constitutional court is an institution of government or whether a constitutional court is an institution of the society. Just keep open the question. This is something on which we will come back.
A big question. Good question. Okay, and now I asked for questions because I, in a sense, want to come and try to explain the peculiarities of the British Constitution. So, let me begin by giving another short quotation from another very distinguished modern political commentator, Alexis de Tocqueville, a French aristocrat who, in the early 19th century, travels to America, travels throughout the America to try to understand the culture of the people, especially by reference to its political conditions. And he writes a classic work called Democracy in America. And what he's doing is saying, this society that's been created by the Americans who broke from the British Crown is a new type of society, a democracy. It's not an aristocracy, it's not a monarchy, it's a democracy. And this is the future. And he's writing Democracy in America for us, the European people, who have monarchy and aristocracies. And he's saying, this is the future. How are we to organize ourselves in the future? And with the coming of democracy, what changes will take place? Now, he has a lot to say about that. Again, I've just taken out a small statement that de Tocqueville makes in Democracy in America, where he's talking about the British Constitution. He says, in England, he means Britain, I'll come back to that. In England, the Constitution may change continually, or rather, it does not in reality exist. So, in Britain, the Constitution may change continually. It's the same notion as Grimm's idea that a Constitution is an empirical phenomenon. As the political conditions change, so the Constitution changes. But then de Tocqueville goes on to say, oh, in reality, it doesn't exist. Why? Because by 1840, he's already accepted that a constitution means a modern type of constitution. If you haven't got a modern constitution, you haven't got a constitution. So he's saying Britain doesn't have a constitution. But then the next sentence explains why. He says, the Parliament is at once a legislature and a constituent assembly. Now, from what Marco said in the introduction, he's already introduced the idea very early on of constituent power. That if you've got a modern sense of a constitution, you've got a constitution that's made by whom? By the people. So the people is collective singular. The people is the constituent power, the power that makes the constitution. And they make a constitution that allocates power between the legislature, the executive, and the judiciary. What de Tocqueville is saying is that the reason Britain doesn't have a modern constitution is not just because it's not written down, but also because the Parliament, in the frame of a modern idea of a constitution, looks like a legislature, but it's also the entire nation assembled. And there's no limit on what the Parliament, acting as a lawmaking institution, can do. So the Parliament is both the legislature and the constituent power. And I'm going to come on in one moment and try to explain in a very straightforward way, I hope, how that came to be and how, because of the central importance of Parliament within our constitutional history, there is not really, we haven't got a separation of powers in that modern template of modern constitutionalism. But first, it's there, so I better say something about it. We British never really studied British constitutional law, traditionally, historically. We studied British constitutional history. Why? Because if ours is a traditional constitution, one can only understand that traditional constitution by understanding the history of a people and the way in which the history of the people is, the political history is reflected through changing institutional structures. So we are entirely historicist. We believe that our culture is determined by our history. But in the late 19th century, the professor of English law at University of Oxford, Albert Venn Dicey, tried to produce a series of lectures that became a classic text, and it's called An Introduction to the Study of the Law of the Constitution. And what Dicey tries to do is to say, we can't continue to teach purely through constitutional history. There are certain basic laws of our Constitution. And so we can understand our Constitution as a rule structure, just as other regimes can understand their Constitution as a rule structure. And he tries to identify the essential rules that make the British Constitution work. And he said there are three fundamental principles that underpin the British constitutional order. And the first is the principle of parliamentary sovereignty, the doctrine of parliamentary sovereignty, which means that there is no legal limitation, no legal or constitutional limitation on the power of Parliament to make law through ordinary legislation. The second is that there is a principle with us of the rule of law. Now, immediately, that doesn't make any sense. Because if Parliament has the power to make any law it wishes, how can there be a principle of the rule of law? Dicey says the rule of law means several things, but he says it's asserting the principle of ordinary, regular, rule-based law as distinct to arbitrary power. Secondly, it means equality before the law, that it doesn't make any difference whether you're a minister of the crown or an ordinary citizen. Your right before the court is to be treated equally in the eyes of the law. Doesn't matter whether you're wealthy or poor, your claim has to be determined according to the rules of law, not your social status. And the third element, more complicated, I'll skate over. It's about the importance of the common law, of building law through precedent to precedent. Because with us, yes, I better say this, with us, we have a tradition not of civil rights, we have a tradition of civil liberties. And what I mean by that is that we have a sense that we are born free and equal in rights, and law, the law made by the Parliament, is command, is domination, is control. So we appeal to our liberties to protect us from the law. And it's a completely different way of looking at the modern relationship from that traditional perspective. Because in the modern constitution, if I ask you, do you have rights? And you say yes, and I say, what's the source of your rights? You turn to a constitutional text where, well, in the American Constitution, you have the first 10 amendments of the American Constitution, the Bill of Rights, where First Amendment, Congress shall make no law prohibiting freedom of speech or restricting the free exercise of religion. So we're saying our rights come from the text. We say we are born free, and law is a constraint on our freedom. So we appeal to our civil liberties to protect us from the law, because the law is what Parliament makes, and its command, thou shalt not. And so the less we have of law, the freer we are. That's our civil liberties tradition. Now, sorry, I'm elaborating that because if Parliament has the right to make any law it wishes, it doesn't really, it's not obvious that it's compatible with this second principle of Dicey's, the rule of law. Parliament could make a law saying, we give the minister the power to detain whoever the minister deems necessary to be detained without cause, without having to provide an explanation. And if Parliament passed a law like that, it would be lawful. You could not say it was unconstitutional. But you could hardly say it was compatible with the rule of law, because it's not regular rules, it's conferral of arbitrary discretionary power. It's making a mockery of the principle of equality before the law because the ministers say so is the law, effectively under that hypothetical statute. And it's entirely incompatible with our civil liberties tradition. So the principle of parliamentary sovereignty and the principle of the rule of law are incompatible ideas. Says Dicey, we reconcile this through a series of practices, cultural, historical, inherited practices that he's going to call constitutional conventions. And these conventions are rules of the Constitution, but they are not rules which are enforceable through courts. These are understandings, habits, practices, usages that are culturally, historically conditioned, that will ensure that even though Parliament has formally that power, Parliament will not exercise that power in a way that's contrary to the principle of the rule of law. So it's our customary habits and practices that try to ensure that these two formally incompatible principles are in practice exercised compatibly, that is, constitutionally, in that traditional historical sense of a constitution. But it relies on a set of understandings, a set of conventional behaviors that are not written down in formal law. And that's why we have a traditional, and that's how we have a traditional constitution that continues through time. I'll come back to the modern, contemporary significance of that in a moment. But first, let me come on to back to that first principle, the Crown in Parliament, as the I'm going to take a 5-minute break after this slide. You were all about to jump. I'm going to take a 5-minute break, well, 5 or 10 minutes as you wish, but after this slide, because after this slide is a more natural break. All I want to do here is to explain what the doctrine of parliamentary sovereignty means, how it comes about. And the origins of the doctrine belong to a set of practices of European political history. There's nothing peculiar about the English traditions here. It's part of a European discourse. But the first differentiation we have to make is the distinction between the king and the crown. What I mean by that is that the king, when I'm saying king, I mean a person. When I say crown, I mean an office, officium. Right back to the 13th century, we see that the king, the English king, in the coronation oath, pledges to uphold the rights of the crown. Now that suggests that the person of the king is taking on the role of an office. The office is the crown. The crown is the king, wouldn't quite express it in the 13th century in this way, but the crown is the king in his public capacity, the symbol of the state, the symbol of the public realm. The duty of the crown, the office of the crown, the office of the king, is to protect, secure, safeguard his subjects. So there's a sense that there's a set of duties and responsibilities that inhere in the office of the crown, and the person who accedes to that office must uphold those duties, responsibilities, and rights. And anybody who knows anything about English constitutional history knows about Magna Carta 1215. And what Magna Carta did was to reduce the powers of the individual king and strengthen the powers of the crown. How? Because what the barons said to King John, effectively, I'm cutting through a very complicated feudal story of the period, but what they're saying is that you can only speak as king when you speak through the office of the crown. And you can only speak as king through the office of the crown when you act through your council. The meeting of the leading barons so the king meets with the barons, the king in council declares a rule, makes law. And the king speaks as king only through the council. It's not what the king desires when he gets out of bed in the morning and says, I declare this. That's not the king speaking as king. The king can speak as king only through the council. And we see, this is a common European practice, and we see that the king's ministers, then we have the doctrine of the seals of state. The king speaks as king only when the document that is drafted is attested with the seal of state. And in the English tradition, we have the Lord Chancellor, who holds the great seal of state, and we have the Lord Privy Seal, who is the minister who holds the king's private seal. And the king speaks as king only when there's a formal document on which the seal is attested. And of course, the seal is held by different people than the king in person. So what you get is an officialization of public power. Initially, it's the king in council that makes law, is the ruling authority. But then the king realizes in order to bind the nation, we need to build up the legitimacy of the king's rule by bringing representatives from the several parts of the kingdom to meet with the king's council to determine certain very important matters of state. And that's the origin of our parliament. So the king would send a message to each of the 40 counties of England to send 2 representatives to come and meet with the king in council to parley, to speak, to discuss. And so we get the king in council in parliament. And that's the origin of our king in parliament, our principle of parliamentary sovereignty. When the representatives come from the several parts of the kingdom to meet with the king in council to deliberate, it's generally big issues like, we are going to war. If it's not France, it's Spain. If it's not Spain, it's Germany. And so on and so forth. But the most, you want to bind the nation. So this is a source of democracy, but it's not experienced as such at the time. The representatives did not have a vote to say, no, I don't think that's a good idea. That was not the way it was. It was to bind the nation. the representatives could hardly say, no, no, no. And most importantly, because I'm going to war, I need taxation. I need money. And I'm going to tax the people. And you have agreed on behalf of the people to be taxed. So it's experienced as an obligation, having to go to Parliament and sign off on these decisions that had been made by the King's Council. But that then becomes the origin of this idea of the King in Council, the King in Parliament, I should say, whereby certain types of decision, to raise taxes, to make laws, can only be done by the King in Parliament. And finally, I've given you the moment when we get parliamentary sovereignty articulated as a doctrine, and this is the moment of the Reformation. It's the moment when Henry VIII, for reasons of state I will not go into now, you probably know more about it than I do, wants to break with the church in Rome. And you have to recognize the church, the Roman church, was a very powerful secular power. It had its own courts, its own ministers, called bishops, its own immunities in English law, from English law, its own jurisdiction in English law. And the king says, I've had enough of this guy in Rome. I'm the king, my writ rules. And through the Act in Restraint of Appeals in 1536, he cuts off any claim to authority of the church. And so he destroys the secular power of the Roman Church in England. But he can do it only through Parliament. He realizes that only by going to Parliament and getting Parliament to agree to this can it be legitimately done. So you have the moment when there's no limitation on the power of Parliament to make law. And he comes to Parliament, I'm giving you the quotation, we stand, he means me, the king, I stand, we stand, it's the royal we stand at no time so high in our estate royal, our status, our royal state, as in the time of Parliament, as in the moment when I come to Parliament, wherein we, me, as head, and you as members, literally members, of one body politic stand united. So the body politic is the state, the entire political community. I, the king, am head of this body. You, the representatives, are the members, arms and legs of the body. We are united in making this decision. And that's the moment where you have sovereign authority, unlimited power of that institution to make and change law. Stop there. 10 minutes?
5-10 minutes?
Whatever, yeah, 5 minutes.
Let's meet at 12:30. If we are ready, we can start again. We have half an hour.
I shall be trying to be very brief. I've only got 3 slides left, but I could probably speak for an hour on each of them. So let me just quickly move to the first one. Well, the next 2 slides are why Britain still has a traditional constitution. And I want to give 2 different types of explanation. One is historical, and the other is philosophical. And they relate to one another. And then the last slide is saying, well, where are we at today? What are the contemporary problems as a consequence of continuing to live with a traditional constitution? But the first point to make on the history is this, that when we reflect on modern constitutions, we see that they are a product of late 18th century political movements. And those political movements were highly influenced by Enlightenment thinking. The Enlightenment is this modern, rationalizing, secularizing idea of philosophy that flourishes throughout Europe in the 18th century. And the Enlightenment thinkers, especially in the political sphere, thinkers like Montesquieu and Rousseau, have a tremendous influence on the thinking of the framers of the American Constitution and the activists behind the French Revolution. And thereafter, you have the two great revolutions of the late 18th century, the American and the French revolutions. You have modern constitutions instituted as an aftermath of a successful revolutionary movement. And from the late 18th century onwards, nations across Europe and then across the world start to draft modern types of constitutions in the aftermath of a revolutionary movement, aftermath of war, breakdown of empires, re-emerge. So you get the breakdown of the Austro-Hungarian Empire and the creation of a series of new nation states. And at these critical junctures, at these critical breakpoints in the history of a political unit, you have renewal. And the moment of renewal is the moment at which a modern constitution is drafted. So either the breakdown of empire, or the revolutionary insurrection, or collapse of authority owing to defeat in war. Now, taking that, reflecting on the British experience, well, we don't go to war. We don't have revolutionary movements. We're a peaceable people who, I don't see many of you smiling yet. No, the English were too revolutionary. They had their revolutionary insurrection in the 17th century. In the 1640s, we had a whole decade of English civil war, with the parliamentary forces vying against the crown, against the king, and the parliamentary forces winning, and the English doing something absolutely terrible. They executed the king. They chopped the head off the king. They chopped the head off the body politic. And then they were shocked because they couldn't conceive of political order without a head. Because the modern constitutional thinking is a product of the 18th century philosophical developments, and we're sitting in the 17th century thinking, how do we restore order when we haven't got a king? The symbol, the central symbol of order. And so we try to make Oliver Cromwell king. And then when he died, we try to give the Lord Protectorate to his son, who was incompetent. And then, so in 1660, we restored the monarchy because we couldn't think of order without a king. So our problem, if we have a problem in the sense of modern constitutional thinking, is that our revolution came too early. And then, for whatever reason, we haven't had successful revolutionary insurrection. We had the Jacobite rebellions in the 18th century, not successful. We have not had utter defeat in war. We've lost imperial wars, but not at home. And so we've never had the moment, the critical constitutional moment, where we can renew ourselves as a nation and therefore adopt a modern constitution. And if you haven't got that critical moment, you cannot, it's very difficult in normal, inverted commas, normal circumstances to say, let's have a new constitution. It has to be a moment of crisis for the nation before that can happen. We've had changes in the nature of our state. Our state is formally the United Kingdom of Great Britain and Northern Ireland. And that comes about through a complicated history by which the English conquers the Welsh very early, so that the Welsh are incorporated, Wales is incorporated into the English state certainly by 1535. So when we talk about English law, English common law, it applies throughout England and Wales. And when we talk technically about the English state, we mean England and Wales. But Scotland became part of the state, not by conquest, but by treaty, by a Treaty of Union of 1707. And Ireland was always subjugated by the English, but complicated history I'm not going to go into. They absorbed into with the Treaty of Union with Scotland, we created the state of Great Britain, and then with the Treaty of Union with Ireland of 1800, we created the state of Great Britain and Ireland, the United Kingdom of Great Britain and Ireland. And then there was the Irish insurrection in 1916 and subsequent civil war in Ireland immediately after the war, and then from 1922, Republic of Ireland, in Irish independence, except for the 6 counties of Northern Ireland where there was a Protestant majority who were unionist. And so we are left with a state called the United Kingdom of Great Britain and Northern Ireland. Complicated history, but dominated by the English and the English ideas of the state continuously. So none of those moments became constitutive moments for us. That's one reason. Now let me come on to a more intriguing one. There's a philosophical reason behind the idea that we are inheritors of a traditional constitution. And this philosophical reason goes something like this. You Europeans, continental Europeans, are creatures of philosophy. You love your abstract ideas, your rational thought. We, the English, are empiricists. What works is good. You can build your castles in the air. What actually works on the ground is what matters. We are suspicious of abstract, intellectualized thought. The French are the epitome of it. And we are the antithetical nation to the French. The French are the great rationalists, we are the great empiricists. And this philosophy, this temperament of the English is well expressed by one of the most interesting, I think most profound of English political philosophers of the 20th century, Michael Oakeshott. And Oakeshott, in a classic essay called Rationalism in Politics, tries to explain this by saying there are 2 types of knowledge. One type of knowledge we are all familiar with, we students, we in universities, we scholars, scientific knowledge. Scientific knowledge, says Oakeshott, is the type of knowledge that can be formulated into rules it's susceptible of being precisely formulated and can be taught and learned. It's what you learn in universities. 2 + 2 = 4. Mathematics is the epitome of scientific knowledge. It's let's reduce the entire world to numbers. And let's build rules, equations. I'm going to reach the limits of my mathematical knowledge very quickly, but we think, let's assume the world can be reduced, that all explanation of the world can be reduced to a series of equations and formulae. And you can teach the logical relationship between these symbols that we create in order to provide us with that insight for try to understand logic and causation. Now, university knowledge, scientific knowledge, is a powerful source of knowledge, but Oakeshott says it's not the only type of knowledge. There's a knowledge that we might call practical knowledge. We might call it traditional knowledge. It's the knowledge that cannot be taught and learned as such. It can only be acquired through experience. And since I'm in Italy, you will understand, the Italians will understand, that cooking is the epitome of practical knowledge. Where do you learn the quality of what it is to be a great cook? Well, we have an expression in English, it might not be entirely politically correct these days. We learn it at our mother's apron strings. We learn it in the kitchen from watching and learning from someone who is skilled in experience and has learned through handed down knowledge what it is to be a good cook. Now, if I don't understand that cooking comes about through that practical knowledge, I might say, look, I'm an intelligent guy. Walk across the road to the bookshop, buy the some fancy cookbook, crack it open on page 90, there's a color photograph of a dish, and on the right-hand side there are 10 simple rules for how you make that dish. Well, I can read, I can follow those instructions, I do what they say, I put it in the oven, I wait the 22.5 minutes, I pull it out. It doesn't look anything like the picture at all. Why not? Because I've misunderstood the nature of the exercise. The cookbook is not the source of knowledge. The source of knowledge is the experience that one has acquired as to what is a good cook. Once you have that experience, that practical knowledge, the cookbook is a crib, a guide. It helps you, because I'm an excellent cook, but I don't remember the precise quantities. But you know, when it says something like knead the dough, well, I have to understand what kneading the dough is and when it just reaches that precise consistency to be read. That has already to be there before I can use the guidebook. That practical knowledge, cookery being an illustration of practical knowledge, is what we, the British, think about governing. We don't have a rule book constitution because ruling is not an exercise in scientific knowledge. It's an exercise of practical knowledge. And this is why in the great European medieval universities across Europe, right at the heart of the medieval universities were three subjects: theology, medicine, and law. Why? Because you inherited Roman law, rational law, principle law that you unpack. The English never taught law in universities. It's not the appropriate subject for university study because it's not scientific knowledge. The common law is a series of particulars and particulars. The common law is, in Latin, lex non scripta, unwritten law. Doesn't mean to say there's no law written down, but the judge, we don't have a career judiciary. Our judges become judges only when they've had 30 years of practice at the bar pleading cases. So our traditions are the young gentlemen from the public schools of England who have been educated in the traditions of rule, go to Oxford and Cambridge colleges, and they study mathematics or they study the classics, and then they go to the Inns of Court. So they don't study law at university, they go to the Inns of Court, where they are apprenticed to a pupil master. And they spend years wandering around, following the pupil master, understanding what it is to be learning the skills of pleading, of drafting, of advocacy, through that similar experience to what it is that you have to, the sort of way you have to learn to be a good cook. And then eventually they are able to make their own way as a barrister. And then after 30 years of that experience of advocacy in the courts, they get appointed to the judiciary. And they have that experience, and the rules are secondary, the cribs. And the common law is unwritten law, and the British Constitution is the unwritten Constitution. It's experience, it's practical knowledge. And that's the philosophical basis behind the mentality of this traditional constitution. So let me quickly come on to I had the last point, the error of rationalism. The error of the rationalist is to assume there's only one type of knowledge, that is scientific knowledge. And Oakeshott would say, no, there's both scientific knowledge and practical knowledge, modern knowledge and traditional knowledge. And the question is, where does your concept of law fit on that spectrum? You know, he's doing it deliberately. There are not two types, there's a sense of a spectrum. And at one end of the spectrum, there's pure scientific knowledge, building rules, mathematics, and the other is, I don't know, maybe cooking. But for our concept of law, our concept of common law, and our concept of constitutional understanding sits in a different place on that spectrum to those legal traditions that come from Roman law and those constitutional traditions that come from modern constitutional thinking. Now, the problem we have is that whether we, the British, like it or not, we live in a rationalist world. Ideological politics, the rise of ideological politics, by which I mean the rise of rule book politics, by which I mean the rise of political parties that follow an ideology, use their ideological power, their rule book power. It doesn't matter what your rule is. It doesn't matter whether your rule is the greatest happiness of the greatest number, the utilitarian philosophy of Jeremy Bentham, or from each according to their ability to each according to their need, Marx, or keep the government off our backs, Hayek. Or doesn't matter what the rule is, what the principle that motivates you. You have a rule book idea of politics, and that's driving your system of government. And so we got rationalist politics in an anti-rationalist constitutional frame. And with the rise of democracy, with the rise of big government, these have, throughout the 20th century, these imposed tremendous strains on the workings of the traditional British constitution. And so we have had to modernize incrementally. And let me tell you that the secret through which we modernized was membership of the European Union. Why? Because the European Union is built on this rationalist edifice. It's what the Germans called a Rechtsgemeinschaft, a community of law. Whatever the beast is, it's not a state that has an army to enforce its will, or great sources of taxation to enforce its will. It can only enforce its will through law. And so the institutions of the European Union, especially the Court of Justice, pushes a rationalist teleological structure of law through in order to build its authority. Entirely antithetical to the English mentality of thinking about law. So, forgetting about the political differences, there are fundamental tensions in the adjustment of our legal order to the European Union. But the European Union, because of EU membership, we've had to modify our doctrine of parliamentary sovereignty, because the European Union can work only with having a hierarchy of laws where European law, when it conflicts with any provision of domestic law, must prevail. So that creates a hierarchy of law that requires us to modify our conception of parliamentary sovereignty, our doctrine, legal doctrine of parliamentary sovereignty. We have had to change our constitutional arrangements to make it more palatable to our fellow members of the European Union. I'll not try to explain that now because it's quite complicated and we've only got a few minutes left. We have introduced the Human Rights Act, which is simply domesticating, is making directly enforceable by our judges the principles laid out in the European Convention on Human Rights, but that then creates a basic structure of rights contrary to our civil liberties tradition, and so we now appeal to the judges to protect us, protect our basic rights as are articulated in the European Convention. Even our devolutionary, we have a very centralized system of government, but we have devolved power certainly to Northern Ireland, Scotland and Wales over the last 30 years or so. We have been able to do so. Let's just take the case of Scotland. We've been able to do so very easily in a legal sense. Why? Because we are part of the European Union. And so when Scotland had its independence referendum 2 years ago, independence didn't really mean independence, because even if they voted for independence and they left the United Kingdom, the two nations would still be both members of the European Union, and therefore there would be no customs barriers, there would be common edifice of rights through the European Convention network. Yeah, that'll do for now. And the Scots had already said, we will maintain the crown, we will keep the Bank of England as the regulator of our currency. So it wasn't genuine, it wasn't classic modern independence, it was self-governing status within an overarching legal structure. When Britain leaves the European Union, there will open up a series of much more intense constitutional questions, and Scotland will once again try to break, if the present government in Scotland has its way, certainly there will be another referendum, but it will be a much more difficult and serious referendum, because there will be the contemplation of a hard border between England and Scotland. And it would be the Scots will then have to adopt the euro, which they weren't proposing to do last time. Fiscal policy will be entirely different. So Brexit has opened up a series of very difficult constitutional questions for us. Who knows what's going to happen over the next year or two as the parties negotiate their way to an outcome. But whatever happens at the end, there will be constitutional issues of a seriousness we've never previously had to face to be addressed. And I don't know whether we have the constitutional imagination to be able to address those very well. I'll stop there. I haven't left much time, but I'm happy to answer whatever questions we have time for.
Yeah, thank you very much for this inspiring lecture, Martin. And yeah. We do not have too much time, but if there is someone who would like to ask some question, some short question, please, you're welcome to do.
Would there be a possibility of England ever getting a modern constitution, or is it too engraved in its culture and pride?
Yeah. I wrote a little bit about this immediately after the referendum result, and I said that the referendum result had posed a series of constitutional questions that we had not really properly been able to address, we hadn't thought about, and part of the main series of constitutional questions that we had to address were those that were the fallout of what I would call the territorial constitution, the relationship between England, Scotland, England, Northern Ireland, England and Wales, and England and Ireland, because although Ireland is an independent country, we have a common travel area, there's no border restriction, never. Even before we were members of the European Union, we had no border immigration control issues between England and Ireland. But England is complicated because London is a separate state. It's a cosmopolitan world city, a major international financial center. If you've been to London, you will see, you get on a London bus and English is the minority language being spoken. French, Italian, Portuguese, it's an entirely cosmopolitan city. And so London is a separate state. And then you have the rest of England who voted to leave. London voted to remain. Scotland voted to remain. The rest of England voted to leave. Wales voted to remain. The English, it's difficult to know. The English, the traditional English constitution that I'm talking about is a constitution that's most clearly protected by the Conservative Party, and not by the majority, well, maybe by the majority, but not by the leadership of the Conservative Party. The Conservatives are split between the traditional Conservatives and neoliberals who see markets as being conducive to prosperity. So it's difficult to say who the English are any longer. I'm from the north of England. My temperament is very different from a southern English person. My ancestry is Irish, not historically English. I'm not the best person to speak about it. But it's a crisis of, I think you put your finger on a good point, because it's a crisis of culture. And we don't know who we are. We have been able to avoid addressing that fundamental question, who are we? And what is the we? Is the we English, or is the we British? Who are the we, the people, who are going to make a constitution? We've avoided that question throughout history for good political reasons, because once you start opening that up, we're okay. And we were able to avoid it by having an empire, because the Scots played a major role in running the empire. But once we ceased to have an empire, then instead of our energies being projected outwards, we have to start looking at ourselves. And it's never good to look at yourself. We will see. Don't know.
Thank you. Well, I have a question about the referendum and the Brexit. The Article 50 of the Lisbon Treaty says that, I'm reading it, any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. But we just said that Britons have an unwritten constitution. So this is a technical question. How are you going to deal with this problem posed by the Article number 50 in this situation?
It's a very good question, and a rather sophisticated question for someone who's just started their constitutional studies course. But the answer is, first, Article 50 was drafted, I suspect, with the intention that it would never be used. So everyone then started reading, after the referendum, no, not before, we started looking at Article 50 and thought, what does it mean? But there has been considerable, there's been nothing but debate about this in Britain for the last 12 months or so, because the question is, could Article 50 be triggered by our government, that is the executive, using its, I don't want to get too technical, prerogative powers, its inherent executive powers to make treaties, to issue the Article 50 notice, or because triggering Article 50 would result in the loss of accrued rights, European Union rights, did it require Parliament to approve, to authorize the government to make the Article 50 ruling? The government, idiotically, in my opinion, what the government should have done was to avoid that discussion by simply going to Parliament 2 weeks after the referendum and put forward before Parliament a one-line bill that says Parliament authorizes the government to trigger Article 50 at the appropriate moment, full stop, and then use its majority to get that through Parliament and give assurances that they would discuss the matter with Parliament. It didn't, and that led to litigation, the Miller case, Miller against the Secretary of State for exiting the European Union, and the High Court ruled that that the government couldn't do it, it had to go to Parliament, and the government again stupidly appealed that to the Supreme Court, and the Supreme Court upheld the original ruling of the High Court. And so there's a huge amount, how much expense is entailed in all these lawyers sitting around making these arguments over the last 12 months, who knows? And what happened after the Supreme Court ruling? The government promoted a one-line bill, well, a bit more than one line, but effectively a one-line bill in Parliament saying Parliament authorised the government to trigger Article 50 at the appropriate moment. So, and some of the crazy constitutional lawyers at home were saying, oh, this is Miller case is the most important constitutional case in a generation. I didn't see it, but yeah, well, it has led to a lot of dispute, but it was not surprising that it required an act of Parliament to authorise the government to trigger Article 50. The government, of course, has triggered Article 50, did so back in June, and we are now slowly negotiating the terms of exit.
Anyone else?
Somebody back there.
So, Professor, you briefly outlined before the process of constitutionalization of what occurred in the United Kingdom. Many argue today that a similar process is somehow necessary on a broader scale, on an international level, or more specifically, at least within the European Union. What do you think about it, and what stage do you think we have reached in this process with regards to the European Union?
I thought the last question was tough. This is the world. The last 50 years has seen a constitutional revolution worldwide. What I mean by that is that 50 years ago, constitutions were boring documents that political scientists, for example, that is, those studying power, would not take much notice of because it's all about power interests and very little about documents. And somehow, because of a series of changes, globalization is one, the second era of modernity, the period of reflexive modernity, whatever one wants to call it, has resulted in constitutions assuming a much greater importance in the regulation of the political life of any unit, states and in institutions beyond state. And so much power is now being exercised by institutions beyond the nation state that many constitutional scholars are now arguing that the only source of legitimacy for the exercise of public power is for that power to be exercised through a constitution. And so when the Germans are in the vanguard of this movement, they can't bear to see public power without it being constitutionalized. So this movement to constitutionalize the United Nations, to constitutionalize the World Treaty Organization, to constitutionalize the European Union, they made a tremendous error in the early years of this millennium when they pushed for a constitutional treaty for the European Union, in my humble opinion. Why? Because the British would never agree to a constitution of the European Union, because they would see that as bolstering even further the legitimacy and authority of the European Union. It's become a very big and important question, and it makes constitutional study much more exciting than it was 30 or 40 years ago. And what you see too is at the nation state level is an astonishing rise of constitutional jurisdiction, the power of constitutional courts. The courts traditionally would say, these are matters of law and those are matters of politics. And if you come to the court with a political issue, they would just say, it's a political question, we, the courts, are not able to deal with it. Now the courts say the Constitution provides this overarching framework that regulates all political life. Therefore, there is no question no political question that does not yield a constitutional answer. And therefore, we, the court, as guardians of the Constitution, have the authority to rule on every question. And that has resulted in the creation of a highly politicized form of constitutional law, again, through a rights revolution that's entirely different to the law of contract, or the method that we use to study contracts or delict or property laws. That legal method is not the method we're applying to address constitutional questions. So we're getting the globalization, a globalizing process, and in its train, we are getting what many scholars call global law and global constitutionalism, and it's an attempt by the lawyers to harness this exercise of political power.
Okay, thank you very much first of all to Professor Laughlin for this lecture, and to all of you for participating. I will see the students of Comparative Constitutional Law tomorrow. Please consider that we have moved the class to 5 to 7. And thank you again. The lecture will be posted on Moodle with the slides, and tomorrow we will have time to come back on specific issues if there are questions. Thank you. See you tomorrow.